Hello, everybody. This is Daniel O'Connor with Bryant O'Connor Law Firm. I'm an attorney. I love estate planning. I think it's very important. It's one of the most meaningful things I do. And today I want to talk to you about 6 common mistakes people make in estate planning. There are more mistakes than this, but these are 6 that we see over and over. And these are the type of mistakes that can lead to disastrous results if they're not addressed in your planning. Mistake number 1 is failing to consider how minor beneficiaries will inherit. Many people don't think about this in their estate planning, but minors, which means children under the age of 18, cannot own property like an adult. If a minor inherits property, essentially the government, a judge, is going to appoint a conservator to represent your child, and you don't know who that would be. And much of their actions will be governed by a court, and they will consistently throughout the child's childhood be required to get consent from a court before they do anything with the child's property. And then when your child turns 18, the property would just be turned over to your child without any strings attached at all. And this can lead to unintended consequences because 18-year-olds, frankly, are not very smart with the resources. They don't have the background or experience to act wisely on their own behalf. And this is why you need to be thoughtful. Parents of young children probably need estate planning more than anyone. I've prepared a much longer form presentation on this subject. I'd encourage you to watch it. You can find it on our website, brianoconnor.com. The second common mistake I see is failing to consider an heir who might contest your estate. So let's just say you nominate, your most responsible child as the executor, and you've got under your will, but you've got another child that may not like that. Every one of your children has to be served with a copy of your will if you have a will. If you don't have a will, they're served with notice of whoever is seeking to administer your estate. And they have a certain amount of time to object, whether they have a good reason to or not. What this means is that one child, or if it's a niece or nephew that's your heir or cousin, can hold up the entire division of your estate just by raising an objection, which will cause litigation in court. It's probably not your intent. Nobody dies wanting their estate to be contested. How do you get around this? Well, a will is not going to do the job because even with a will, every one of your heirs has to be served with a copy of it before it's probated. Often a trust is the right answer because if a properly funded trust, you can avoid probate, and which makes it much more difficult for an unhappy heir to file some kind of contest and hold up administration of your estate. Okay, mistake number 3 is failing to plan for incapacity. Incapacity is when you're unable to care for yourself, either mentally or physically, and you need somebody else to take care of you. One basic document that kind of takes care of this is a power of attorney for financial decisions, or what we call in Georgia an advance directive for healthcare decisions. Those are 2 very important documents that are part of any planning that we do. But if you really want to get into the details, and if you have, resources that could be used to take care of you, it's probably to your advantage to use a living trust. A living trust has very specific instructions on whose benefit your property is supposed to be used for when you're incapacitated, including your children. And it's something a lot of people don't think about, but it's something that can certainly be planned for. Mistake number 4 is failing to give the appropriate powers to your personal representative. This is a big mistake I see in a lot of people who try to do their own estate planning. A will that doesn't give your executor appropriate powers is going to result in them needing a lot of court supervision and needing to get permission from the court to do every little step of administering your estate. A good attorney is going to draft a document in a way that makes their job much easier. So this is one of the reasons why you shouldn't draft your own estate plan. Mistake number 5 is failing to maintain and update an inventory of assets. You can't, when you die, there's not some magical database that just lists everything that you own. If you haven't listed your assets in a way that's very easy for someone to follow, it's very possible that the people you leave behind won't know everything that you owned, which could lead to some property ending up in the Department of Unclaimed Property of the state. That's certainly not your intention. As part of our estate planning here at Brian O'Connor Law Firm, we help you build a family wealth inventory so that whoever you leave behind is able to locate and find your assets and make sure they get to the people you intend. And this is something and while we're talking about this, estate planning is not a one-time thing. It's something that you need to update through your life, and you need to keep your asset inventory updated. And finally, number 6 is failing to consider intangible assets. Intangible assets are not something that traditional lawyers talk about a lot, but they're probably the most important things in your estate plan. Your most important assets are actually probably the humans in your family that you're going to leave behind. They could be your church or an organization that you care about, but typically it's humans, human resources. And that's what you care about, the time you've invested in them, your rituals, traditions, your anything like that. These are the things that are going to live on past you. If you leave your hard-earned money to people who aren't equipped and don't share some common purpose with you, I don't know what this is all about. I mean, what we're trying to do is pass on a legacy. And if you fail to consider your intangible assets, you're missing out. But if you handle your estate planning with our firm, it's something you will have the opportunity to pass on. And our clients who do this, it's one of the happiest things for me to do is to feel their emotion and seeing how meaningful it is to pass those types of things on. So if you want to avoid making these mistakes, I'd encourage you to meet with an attorney. I can assure you that you're not going to make these mistakes if you do your planning with us and follow our advice. Our motto is plan, protect, and pass it on. We do this very comprehensively. We do it the right way. We try not to cut corners. I'd be happy to talk to you. I offer 10-minute phone calls with anybody who wants to talk about this. And if you're really serious and you're ready to do some homework, we'd love to schedule you for a family wealth planning session. All you have to do is text us at our phone number, 912-537-9021, or give us a call and get on our calendar. We're booked up mostly for the next couple months, but we may be able to squeeze you in. I look forward to hearing from you, and take care.